democracy movement, indigenous movement, and we have a series of movement for ensure the rights of the people. So new constitution will be one of the Bill of Rights for the Nepalese people. However, we are able to ensure these things or not. Draft constitution will show, and draft constitution and our new constitution will reflect our effort to whatever and however we did labor and we did lobby and we did exercise, that will be reflect in a new constitution. In this concerns, this valuable international conference is going to be held. Now, this is our pleasure. Very eminent speakers and very eminent commentator are here. We will see much more. We will hear much more from the panelists and commentator. So I'm not going to take. It's just coincidence. Not a conspiracy. Okay, we have two speakers, key presenters. You have already given a time schedule. 15 to 18 minutes is allotted for the speakers. Then we have a very eminent commentators. 4 commentators we have. Each 10 minutes is allotted. It is because I'm mentioning about the time. At the time of deliberation, probably I may not interrupt. Speakers and panelists will understand themselves. So, first of all, I would like to request Professor Yashpal Ghai. Everybody, I have no doubt everybody knows Yashpal Ghai. He's very familiar to Nepal and Nepalese people and Nepalese constitutional expert too. Not only Nepal, he is very familiar throughout the world. He has very big knowledge in his mind. Once I had heard from other experts, in his mind, more than 40 constitution is available in his mind very in instant. Yeah. It is not needed to help of the computer chips and laptops and pen drives also. I will not trying to more introduce Yashpal Ghai. Now, may I request Professor Yashpal Ghai to present his very valuable thoughts within 15 to 18 minutes. Thank you.
Thank you very much, Kimlal. I'm delighted you are chairing this session. I want to thank Bipin, Surya, and other friends who have organized this meeting and invited me. I will try to stick to the 18 minutes, which is the maximum I have, and so I want to go straight into my paper. My paper has been distributed this morning, but the ink is rather faint, so you may have some difficulty reading it. I start my paper by looking at the complexity of social, economic, political change in Nepal in the last few years, continuing into this process of constitution making. And I noticed some of the transitions which are underway from monarchy to republic, from authoritarian rule to democracy and human rights, from hegemonic rule to participatory democracy, from a Hindu state to a secular state, and perhaps structurally most important, from a unitary state to a federal state with autonomy, as it is put in the interim constitution. Each one of these is a very complex transition, and what Nepal has to do is to manage simultaneously these different transitions. And these transitions are about at least two things. They are about a new identity, a new, one might even say, nationalism for Nepal, as well as the restructuring of the state. So both nation building and state building are very much the emphasis in the discussions, in the Constituent Assembly, in the agenda for the new constitution. So I think one has to keep in mind this complexity when looking at the drafts of the various thematic committees. I have discussed some of the complexity in my paper, and maybe I'll come back to that. The second point I want to make is that in a way, the issue of minorities, including indigenous peoples, in a way runs through the entire document. The leitmotif of this constitution is the place of minorities in the new Nepal, where they fit in the constitutional framework, in the economy, in politics, in society more broadly. And so it's really very hard to discuss the topic that I have without going almost through every chapter in the draft constitution, in the interim constitution. I am somewhat disadvantaged in that the two critical chapters or reports are not yet available. The one on the structure of the state, which will include the provisions on federalism and autonomy, as well as the paper on the executive, which is important because in a way the idea is to have an inclusive state, and it is the executive where the power of the state for the most part resides. And so I'm at some disadvantage, but I think one could correctly, reasonably assume that there would be a very significant emphasis, at least on the chapter on federalism and autonomy, on the concerns of the minority communities. And then the documents that have come from the thematic committees. I start with the 1990 Constitution because I wanted to show the vision of Nepal that dominated that document from the appointment for the monarchy, the emphasis on Hindu religion, the emphasis on Nepali language, hegemonic system that was consolidated in the 1990 Constitution. That Nepal is a harmonious society and we must preserve that. And then the challenge to that vision or that model of Nepal, which was expressed which in fact starts the process that we are now discussing, enacted as a temporary measure until a final constitution was adopted. Also a very detailed document in itself, much longer than most interim constitutions. The major theme, of course, is inclusion, inclusive state, social justice, recognition of diversities of different kind, of language, of religion, of cultures, and it tries to build a society or a state with many different communities. And if you read the interim constitution or the report of the thematic committees, the one phrase that recurs all the time is communities, and I want to say something about the community emphasis in the conclusion of my remarks. I don't have time to go through the provisions of the interim constitution. I do that in my paper at some length. But the main theme, I think, of the interim constitution responds to the aspirations of minorities. In my paper, I have identified what I think, and I was staying in Nepal, as some of you know, during that period. I came here just when the Andolan took place, was taking place in late April, May of 2006. And then as I read the debates and the aspirations of the minorities, I thought that what they were wanting was equality and the elimination of all forms of discrimination. Then they wanted fair and effective representation in state institutions. They wanted a place of honor and dignity in society. They wanted affirmative action, including reservations, other methods of redressing past inequalities. They wanted a secure right to citizenship, because at that time, a number of people did not have citizenship. There were problems of law, problems of documentation, and a large number of people were effectively disenfranchised. They wanted a secular state which would recognize the diversity of religions, and more broadly, they wanted constitutional recognition of diversity. And they wanted self-government through a federal system, probably, hopefully, from their point of view, based on language, religion, ethnicity, regionalism, forms of identity which were emerging very strongly during that period. And so as I then looked at the interim constitution with these 5 or 6 objectives, I find a fair reflection. It is true, of course, that the original interim constitution didn't fully acknowledge this agenda, but with amendments which were made, especially in regard to federalism and affirmative action, one would say that the principal elements of this agenda were acknowledged and in some cases set out in detail. The one area where there wasn't detail was federalism, which in fact is the only binding commitment in the interim constitution governing the Constituent Assembly. The Assembly is required to set up a system of federalism with autonomy, expression very common in Nepal, federalism with autonomy and self-government, and so the features or the structure of federalism was to be expressed in the new constitution. So as I read the drafts of the different thematic committees, I could see that much inspiration was drawn from the interim constitution, and many provisions are almost word for word as they appear in the interim constitution. But the 2 issues not covered in the interim constitution for the future, executive and form of federalism, have yet to be determined, and it's likely that in both cases perhaps we shall get a menu rather than a prescription. So there'll be further choices to be made in these regards. Again, when I looked at the thematic reports, I was trying to see, looking for 2 things. One was a vision of Nepal, if there was a very clear expression, and the document that I found most useful in that is the report of the Committee on Social Solidarity, Articles 9 and 10, which for me gave a good outline of the vision of future Nepal, what I call nation building element, and Article 10, which then reflects the obligations of the state to to bring about that vision and discrimination, as well as either the discretion or indeed in some cases the obligation to take measures introduced as binding obligations. And of course, these socioeconomic rights are extremely aspirations of many people in Nepal and everywhere. I won't go through the provisions in the key areas of language, religion, citizenship, affirmative action, constitution, and I would say on the whole meet many of the concerns of minorities. I want to spend a little for which poetry is completely acceptable, but it is also a binding legal document, or substantial parts of it are, which civil servants, parliament, civil society, and eventually judges will have to grapple with. And I have said in my paper that the interim constitution and now the thematic committees have followed the drafting style, written very well. There's no doubt as to, for the most part, what it means. It's the economy of constitution. And the same is reflected in the thematic committees, which of course overlap, and I'm sure the overlap. Extremely important when the Constitution Committee pulls everything together, that they see they must justify every single word they put in the document. Does it add to anything? Do we need it? Do we need this statement for the 10th time? And things like that, because it is not that tedious, but also they can cause a lot of confusion. In categories mentioned are not quite the same. Then you begin to wonder, is this qualifying the earlier article? So, you know, the lawyers will understand what I'm saying. It's an extremely complex area of rights of different communities. Now, I think the interim constitution provisions for the Constituent Assembly have problems. Maybe in the question time we can look at that, and I think a different system may need to be examined. And then there are too many commissions which seem to have the primary responsibility for implementing provisions for minorities, and I think you know, having 8, 9, 10 commissions, the General Human Rights Commission, Dalits, Muslims, women, Janjatis, and some other communities, it seems to me to be overkill. You will have so many commissions, they'll be competing, there won't be enough resources. And what you need to build, I think, is an integrated political community of Nepal. And so I want to conclude by saying that the challenge is enormous. Provisions in the documents are, I think, respond to the concerns of minorities, but there's also a bit of a lack of, it's as if there are two processes going on. Here are the minorities, and I notice in this room, a large majority are minority groups, and so as if it's a marginal issue, so the minorities are engaging on the question of the rights, institutions for the right. Then there's another debate going on, maybe in the high-level mechanism, which is concerned with very different issues, different structure of the state, intra-elite competitions. So there are two processes going on, and they're not coming together, in my view, of reading of these documents. So what you need to do is produce a really integrated document, and I think you need to work as much for national unity as you work for the rights of minorities. Thank you very much.
Thank you, Professor Guy. To reality check and what is the present condition of Nepal, and in what condition new constitution is going to be right. Salient feature of the 1990 constitution and interim constitution is a little bit expressed. And about the new agenda of the minority rights was established from the April movement. And community, the new word in an interim constitution and new draft reports also. There is a community and it need to be clarified. And most of the provisions of the draft reports has aspiration drawn from the interim constitution And the draft reports is the characteristics, salient features of the draft report is vision and social solidarity is major focus. Remarks, Professor Guy. Now I would like to request Dr. Jill Cottrell. She is also not less than familiar to Nepal, everybody you know, and she will speak about the women's rights issues under the new constitution. Jill.
Namaste. Good morning to everybody, and let me repeat the thanks to the organizers of the conference and indeed to International IDEA for bringing us back to Nepal, which is always a great pleasure, and to see so many old friends. Most of the faces in this room are familiar faces to us both. And to give us the chance to express some sort of preliminary views upon the proposals for a new constitution. I'm going to talk about women's issues, and mostly about the proposals for rights for women, although I think it's also very important for women to not to forget that all the bits of the Constitution are important for women just as much as to everybody else. They have an interest in how the system of government generally works, because however many rights you have, they will be useless unless they are set into the context of a constitution which is actually functioning properly from an administrative and political and other point of view. But I am going to focus on some of the main things that I have noticed, and indeed as other people have noticed too. I, for example, had the opportunity to see a paper written by the CA women members commenting on some of the proposals, and that, in fact, I begin with the issue of citizenship, which is one of the issues that has concerned them. The interim constitution was a great improvement on the previous situation, although not still perfect for women. But I noticed and the CA women members also noticed that some ways the proposals that come in the Human Rights and Directive Principles Committee for Citizenship are maybe a backward step as far as women are concerned. Whereas the interim constitution was very firm about equal rights, except in the one respect, for men and women, it now seems that it's now drafted in gender-neutral language, but I wonder whether, in fact, it will operate in a gender-neutral way. And particularly, the fact that a spouse, a foreigner who marries a Nepali, can now not become a citizen until 15 years of residence in the country. And it may be that there are more foreign women who marry Nepalis than foreign men who marry Nepali women, and these things don't in fact often operate equally. And I'm feeling that perhaps there's developed a bit of a suspicious attitude and a possessiveness about citizenship, which is a little bit at odds with the spirit of the Jana Andolan. But one particular issue is that on children whose mothers are known as Nepalis, but whose fathers are unknown. Now, we all know that one group of women of whom that might be true would be people who are engaged in the sex trade. They often do not know who their children are. And of course, among the groups within Nepal who have been very active and about whom there's been a great deal of concern have been the Badi. And they were women who now, of course, are not supposed to be restricted in their choice of occupation, but still, practices tend to die hard. They will find that their child can become a Nepali, but not a Nepali by birth, only a Nepali by naturalization. which means they cannot become president, or a small number of other offices, which are restricted in the other aspects of the drafts to citizens by birth. There is still in the human rights provisions something of a tendency to restrict rights to citizens, particularly what are called the fundamental freedoms of expression and so on. And again, this, number one, is in principle, I think, undesirable unless there's a very good reason for restricting a right to citizen, such as the right to vote. Secondly, there have always been some groups in Nepali society who have found it more difficult to establish their rights to citizenship than others. And so this will hit them harder. Everybody in the country should have freedom of expression. Everybody in the country should have most of the freedoms and rights other than those for which there is a good reason to restrict them to citizens. Then there's a question of indirect discrimination, which doesn't seem to be addressed. That is on equality. Everybody should be equal. Yes, the Constitution, the draft suggests this quite firmly and in several different ways. But it does not say either that this should be not only an intentional, designed discrimination, but also those things which are discriminatory in the way they work. The Convention on the Elimination of Discrimination Against Women says discrimination in effect or intention, which is another way of putting the same thing. Another issue of rights is, are all rights something which the citizen enforces against the state? Or can the citizen complain against other citizens or organizations? What we call horizontal application of human rights. Well, there are some instances, as indeed there have been in earlier constitutions, where it seems clear that citizens also owe an obligation to respect human rights of others. So, for example, equal pay for equal work, and social security in work should be not discriminatory as between men and women. Should be not affected by issues of race, ethnicity, discrimination. Surely everybody owes a duty, at least a moral duty, to respect, and says that rights and duties operate between citizens as well as between the state and citizens, recognizing that occasionally it's just not appropriate. But as far as possible, the rights would operate in a horizontal. And the jurisprudence about economic, social, and cultural rights, that is, the state has a duty not only to respect our unfortunate consequences, it may enable the courts and others to say, you don't have a right, you have a right. Please may remember that there was a right of freedom of information under the 1990 Constitution, and it took 17 years before. But it's very easy for this to be used, in a sense, as an excuse for not making the right effective. The interim constitution and the draft is the inclusion of far more economic, social, and cultural rights as rights. As well as education, which was included to some extent as a right before, rather than putting most of those rights as guiding principles under again, the South African Constitution drafters tried to make this very clear, using the concept of the respect that must be shown towards improving recognition and achievement of rights. But that side, free and compulsory primary education, which is an obligation Nepal accepted when it ratified the Covenant on Economic, Social, and Cultural Rights. And among those issues is the question of impunity. A sense that many people in society, especially powerful people in society, do not actually get punished for the things they do. And I think a constitution can actually do something to tackle issues of impunity. But before I move on to that for a moment, let me just say something else about this business of saying there must be a law. I wonder whether the Constitution in the transitional provisions could say, where the Bill of Rights or the Human Rights say there must be a law, no existing law to fulfill that right may be repealed unless and until it is replaced by a new law which is at least as good, if not more, protective of rights. And that secondly, the relevant commission must, as soon as the Constitution is passed, undertake a review of the law in that particular area and propose within a certain length of time, 18 months, 2 years, new law to reinforce and strengthen the protection in that area. But on the specific issue of impunity, I would suggest that the Constitution should have a good system of prosecutions. Now, for the first time, the draft on the judiciary proposes a Director of Public Prosecutions mentioned in the Constitution. But the Director of Public Prosecutions is to be directed by the Attorney General, and the Attorney General is to be appointed by the government and holds office only as long as the government wants him to be there. So in other words, the Attorney General is somebody who is subject to, is not independent of government, and the Director of Public Prosecutions is somebody who is not independent of the Attorney General. So there would be no independent system of prosecutions. Then you need a sort of attitude of impunity. And I'm not sure, and that was, I gather, discussed in the session yesterday on the judicial review, that the chapter on judiciary is totally imbued with an idea of equality before the law, which is very important. Especially when you consider that violence against women is often an important source of violence against women, apart from the domestic scene, is often security forces, the police, and so on. And it must be clear in the Constitution that they are bound to observe human rights, that there should be civilian control over the security forces. There must be mechanisms to control them, including that human rights abuses should be tried in the ordinary courts and not by special courts for the military. I think this is probably the sort of thing that's being discussed on the other side of the corridor. Then on the subject of enforcement, oh yes, also the courts will be very important, and the whole idea of public interest litigation. And I was looking, and I may be wrong, I couldn't see a provision that replicated the 1990 Constitution provision about a broad idea of who can bring cases to court to enforce rights. It's very important. Public interest litigation has been very important in Nepal, although, as the gentleman on my left would know, I think, say, many directives of the Supreme Court in the area of public interest litigation have received less than the respect that they deserve from the authorities. This is a serious problem. But you need it there. Time is not to retreat from the possibility of the courts enforcing rights in this way. I'm not saying there's no room for directive principles. I think there may be. Part of the aspirations of Nepal may be possible only to reflect at this point as directive principles. But what I would really like to see the Harmonization Constitution Committee do is to sort of take away all the directive principles and see whether there's anything missing. If as much as possible should be a right, clearly expressed, able to be enforced, and only where it is really necessary to have directive principles should there be a directive principles. Otherwise, I'm afraid that what you do is to devalue both the rights and the directive principles. Thank you very much.
Thank you for your remarks. Indirect discrimination, also she rightly pointed out, duties and effectiveness of interim constitution and draft reports, and inclusion and violence against women and punishable according to law. It means it's made ineffective. Her remarks were that. Impunity and effective prosecution, her recommendation was that. Time is already allotted 10 minutes each. Now, I would like to request Professor Dr. Om Gurung, who is from Department of Sociology. He is a very active intellectual and indigenous rights and others. Several areas he has expertise. I would like to request Dr. Om Gurung.
Thank you, Chair, and thank you, organizer, for inviting me to comment on the rights of indigenous peoples and minorities. But I have difficulties for three reasons. First, commenting a paper is more difficult than writing a paper. So it is a tough job for me. Second, I have had no time or no opportunity to go through the paper. So I have I have a very weak comment on his paper. Third, Professor S. Ghai is an expert on constitution making. I am not expert on that subject. I am, by training, I am an anthropologist. So I know a little bit about the culture, but I don't know much about the constitutions or the legal aspect of the paper. But anyway, I will make a very brief comment because I have my own weaknesses, as I stated. So my comment will be very much shallow at this point. I very quickly reviewed through the paper of Professor S. Ghai. I have not gone through the paper of Jill Kotel because it's on women. So some other colleagues will comment on her paper. But I would like to make some observations on the paper of Professor S. Ghai on rights of minorities and indigenous peoples. I agree with Professor S. Ghai that the various committees, thematic committee on Constitution Assembly has used a lot of terminologies which are very much confusing, very vague, not clear. And in the case of indigenous peoples, they have lumped together with minorities, which is, I think, conceptually very wrong idea to lump together with minorities, because minorities and the indigenous peoples are very different in cultural context, historical context, social context, and the context of other aspect. Here they define minorities only in terms of the size of populations. But we indigenous peoples do not think that we are in minority. Of course, we also agree that, when there is a question of power sharing, then indigenous peoples also fall under the category of minorities. But so far as the size of the population is concerned, they are not. Of course, in the context of South Asia, we also agree that minorities are defined in terms of power sharing and political domination. But the thematic communities on the rights of minorities and the marginalized communities, they have mismatched together, and it makes things very unclear. So what we had suggested that there should be a special thematic committee on indigenous peoples. their problems are very different, their aspirations are very different, and their rights also, their demand of rights also very different. They have the issue of land, they have the issue of language, they have the issue of culture, they have the issue of religion. But other minorities, for example, described in this paper, Dalits, Madhesis, and women, they don't have this type of problems. So indigenous people should not be merged together with the minorities. That was our concerns, and Professor S. Guys has very clearly written that all these types of the terms should not be put together. They should be put separately. So this makes things very much unclear, very confusing, sometimes very much misleading. Also, he has written that there are so many weaknesses, pitfalls in the interim constitutions also, and the drafting the new constitution also has so many problems because of these confusing terms used very confusingly. And so to me, the thematic committee has used various terms which I think a terminological subterfuge. That's I call in Nepal this sabdajal. These types of terminological subterfuge creates a lot of problems. But he is very much concerns with the national unity, nation building, the state building, very much concerns with communal harmony. And he has a, I think whether I am right or wrong, but he will, he will correct me. He has a assimilative approach, where he, and in his paper he says that the citizenship should be Nepali, one citizenship. So recognized, they are respected by the nation, by the state. Or they are very much worried about national harmony and national unity. They always have the preconception that Nepal was in a state of harmony. There was and there is always a conflict in our society, and if we look at the history of the Rana period, even earlier that, we find that there was a conflict between communities against the Rana regime. There were Tamang revolt, there were Limbu revolt, Rai revolt, the Gurung revolt. So there is the scholars, even by political leaders and the other civil society activists. So that is the reality. So conflict is always there, and this conflict is still going on in Nepal. So our major concern is how to deals very slightly about those things. It has not been explicitly mentioned in these papers. He talks about the the proposal for the drafting constitutions, and he mentions somewhere that representation should remain in the other the marginalized groups, but he's arguing that this representation should be based on populations of each ethnic groups. That is the only way. Constitutions of things from the interim constitutions, which are very much progressive compared to the previous constitutions. But for your information, I have been reported by a community from Dolha district amount of political change. The state has been declared a federal, but in our day-to-day life, we have not been experiencing the spirit of federal. And now in the new constitutions,